The Supremacy Clause is a powerful thing. Valid federal law is the supreme law of the land, and it binds the states. It even binds the judges sitting in the state's own courtrooms who must apply it against the law of their own state. So here is a natural thought, and it is wrong. If federal law is supreme, then surely the federal government can simply command the states to carry it out. Tell the state legislatures what laws to pass. Tell the state's officers what programs to run. Why not? The answer is one of the hardest structural limits in the entire Constitution, and it has a name. It is called the anti-commandeering principle. Start with what is true, because the limit only makes sense against it. State officials really are bound to the federal Constitution. Article 6 says so directly. It says that the members of the state legislatures and all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution. Every state legislator, every state judge, every state executive officer takes an oath to the federal Constitution. A state judge must enforce federal supremacy even when it cuts against the judge's own state. So state officials are not strangers to the federal order. They are sworn into it. But being bound by the Constitution is not the same thing as being commanded by the Congress, and that is the whole distinction. The oath binds state officers to the supreme law. It does not hand the federal government a remote control for the state government. The anti-commandeering principle says that the federal government cannot compel a state to enact a law and cannot compel a state's own officers to administer or enforce a federal program. It can govern people directly within its powers. What it cannot do is conscript the states themselves to do the governing for it. The court drew this line sharply in 1992 in a case called New York against the United States. Congress was trying to solve a genuinely hard problem, what to do with low-level radioactive waste, and it leaned on the states to handle it. One provision went too far. It told the states that they must either regulate the waste according to Congress's instructions or else take title to the waste themselves and become legally responsible for it. Regulate our way, in other words, or own the problem. Justice O'Connor, writing for the court, struck that provision down. Congress, she explained, cannot simply commandeer the legislative processes of the states by directly compelling them to enact and enforce a federal regulatory program. The federal government may not order a state legislature to legislate. And notice the reason the court gave, because it is about something deeper than state pride. It is about accountability, about you being able to tell which government did what. When the federal government makes a decision and then forces the states to carry it out and take the blame, the lines blur. Voters see their state officials administering an unpopular program and aim their anger there, never knowing the command came from Washington. Commandeering lets the government that made the choice hide behind the government that was forced to execute it. The Constitution keeps the two sovereigns separate, partly so that each one answers for its own choices. 5 years later, the court extended the principle from legislatures to officers. The case was Prince against the United States in 1997. A federal gun control law required local law enforcement officers, sheriffs in practice, to conduct background checks on people trying to buy handguns, at least for an interim period while a national system was built. The checks themselves were federal policy. The labor was conscripted from state and local officers. Justice Scalia, writing for the court, said the federal government could not do that either. New York had forbidden Congress from commandeering state legislatures. Prince held that Congress likewise cannot commandeer state executive officers to administer or enforce a federal program. The center cannot turn a county sheriff into a federal agent by statute. Underneath both cases sits a single sentence of constitutional text, and it is worth hearing in full. It is the 10th Amendment. The powers not delegated to the United States by the Constitution nor prohibited by it to the states are reserved to the states respectively or to the people. That is the textual backstop for everything in this episode. The federal government's powers are the delegated ones, the ones on the list. The power to command the state governments themselves was never delegated. It stayed with the states. Anti-commandeering is just that reservation, made concrete. Now this is a limit, not a wall around the states. The federal government has real tools that come right up to the line without crossing it. It can regulate individuals directly. A federal law can tell a person what to do anywhere in the country so long as it is within an enumerated power. And it can offer the states a deal, federal money with conditions attached, in exchange for the state's voluntary cooperation. States take those deals all the time. That is what makes so much of American government a partnership between the two levels. What the federal government cannot do is skip the deal and simply issue the order. Cooperation it may buy or invite, administration it may not conscript. And that is exactly where the hard cases live, at the boundary between an offer and an order. When does a financial incentive become so large, so impossible to refuse, that it stops being a genuine choice and becomes coercion in everything but name? When does cooperate and here is funding cross over into comply or else? The principle is clear at its center and contested at its edge, and the edge is where the litigation happens. So here is the shape of the limit. The center is supreme within its lane. Its valid laws bind the states and bind the officials who serve them. But it cannot reach into a state government and make it the center's own field office. The states are not administrative subdivisions of the national government, waiting for instructions. They are separate sovereigns with their own legislatures to command and their own officers to direct. The federal government governs people, it does not get to govern the states. How separate are these two sovereigns, really? Separate enough that the same single act, one thing a person does on one afternoon, can be a crime against both of them at once, prosecuted twice in two courtrooms, without the Constitution's clearest protection against repeat trials saying a word about it. That is where we go next.